Money Radio, good afternoon, and thank you for joining us. Time to talk real estate with Laura Bramnick from TalkRealEstateAZ.com. And Laura, of course, is a regular guest to the Financial Review. She's an attorney, she's a consumer advocate, she's a realtor as well. She can help with residential or commercial or land transactions. And Laura holds an active Arizona real estate license. She's been a certified instructor for the Arizona Department of Real Estate and licensed with the State Bar of Arizona. Laura, good to see you again.
Great to be here, Sinclair.
And you brought a guest.
I brought Kim Stamatelos.
Yes.
She was here with me last week, and we are talking about attorney billing.
Important topic, and we mentioned that your billing sometimes is a little bit different. If somebody hires you as a real estate agent for a transaction, a purchase or a sale, you can provide legal advice as part of that process.
Yes, and I can represent them as the realtor, and I will also give them legal advice. And so they have a twofer, as we've talked about before,
Right.
which means that they can be protected in the transaction and don't have to worry that they don't understand legally what's going on.
Very helpful when it comes to that. Now, you explain that up front, and that's part of the whole process, is explaining it up front.
Yeah, it's important, I think, to be clear about how you charge, what you charge, and what the expectations are. The big issues come when you don't know how contentious a matter is going to be.
Okay. And you also handle just real estate cases that may
Yes.
not involve your work as a realtor.
Yes, and primarily I do bill hourly. I do occasionally bill flat fee. It depends what the matter is. But it's interesting, I don't do contingent fees, and I don't think Kim does either.
No.
I don't think you're allowed to, are you, Kim, in family law?
I don't believe you are. I don't know anyone who does.
Kim, you also work as a mediator.
Correct.
This is your area of specialty. You teach this at Drake University.
That's correct.
You've written a book, The Compassionate Lawyer,
Yes.
and talk about the idea of mediation as an important part of the law. If someone can reach mediation, it's generally considered to be cheaper. We look at this whole thing, we know that if we go to trial, it's going to be more expensive. Mediation should be cheaper. There are various ways, it seems, to lower legal expenses. Is the legal profession always doing what they can to lower those expenses?
We like to think that they are, but a lot of it depends on the attitude of the lawyer as to what avenues they're going to take to resolve the matter. There are still some lawyers that I call old paradigm lawyers that really think going to trial and being very aggressive and getting before a judge as often as you can is the best way to resolve a dispute. And that can be quite costly. As Laura described in the consultation, you need to identify what methods you want to pursue in order to resolve your differences. Many compassionate lawyers will try to be peacemakers, will use the mediation process, will use negotiation, will use things other than the courtroom to try to resolve things. And you have to have a conversation with the lawyer to make sure that that's the kind of lawyer you're hiring if that's the way you want to pursue it. If you want a sword fighter, if you want someone that's going to destroy the other side, or you have a vindictive approach or something, you're probably not going to be happy with lawyers like Laura and I, because that's not what we think is best for the clients that we work with. But constant communication with the lawyer as to what avenues you're going to pursue, what methods you're going to pursue, is really, really critical.
When it comes to billing, someone meets with you, and we talked about this idea a little bit last week. They meet with you, and you try and give them some idea of what they might be able to expect. So you give them an estimate.
Well, one of the things I do is I try to explain to them what has happened in past cases. You know, meaning I've handled this kind of case many times, and I've had it cost as little as $1,000 and as much as $5,000. And I try to explain the reason that the $5,000 case cost more.
Mm-hmm.
So, and then I try to relate it to their matter. Well, you have this part of that expensive case, but not this part. So I think that your matter will probably fall somewhere about halfway in the middle. But if it doesn't settle and it has to go to trial, or if maybe once you get the information, because at a consult, you don't have all the documents.
Right.
Once you start to get the documents, if there's problems with the documents, or there's documents missing, or maybe some of the agreements were verbal, especially in real estate, that becomes a huge issue. That can become more time-consuming and more costly.
Is there anything we can do if we have a dispute with an attorney over what they've billed?
Yes, there is an organization that you can go to in every state, and in our state, it's called the Fee Arbitration Committee. I'm actually a member of the Fee Arbitration Committee in Iowa. And so what happens is people that have disputes over how they've been charged will come and file a claim, and they'll come before this tribunal of attorneys. And the attorneys will look and determine whether the client has been billed fairly or not. The primary thing that we're looking for right out of the gate was there a signed fee agreement? And I think for your listening audience, if nothing else is taken away from the discussion other than look at what you're signing, understand what you're signing. Many lawyers have volumes of pages in a fee agreement with a lot of fine print.
Do I need to get another attorney to review the?
Sometimes you do, that's correct, but some attorneys charge for postage and photocopies. Some attorneys charge interest if you don't pay your bill on time. And so these are things that then can increase your costs. Some attorneys will bill you monthly after the retainer is exhausted. Some attorneys require you to replenish the retainer or the advance fee in full. So these are all, Kim has another way that she bills called Evergreen. And I don't do that, but maybe you can explain what that is.
An evergreen retainer is like a security deposit on a lease. You put it there and you park it in the trust account, but you don't bill against it. It's kind of left at the very end in case the client runs out of money towards the end. You know, what is interesting is Laura and I were talking about this today. Both of us have like a page and a half fee agreement. It was interesting. We hadn't compared notes on that, but
that's not overly complicated.
Not overly complicated. It's not in legalese. It's very easy to look at. And when we do consults, we both talk to the client and go over the fee agreement.
I think one of the great things Laura does is when she can get involved in something early enough, she can help prevent anything going to a lawsuit.
Absolutely.
By advising someone properly so that they don't run across these landmines that can sometimes be in a real estate transaction.
That's what a lawyer should be doing.
Yeah, a compassionate lawyer anyway.
Indeed.
That's the title of your book, Kim Stamatelos, The Compassionate Lawyer. And Laura Bramnick, of course, is an attorney and a realtor, and you can contact her at talkrealestateaz.com, talkrealestateaz.com. Phone is 480-624-2705, 480-624-2705. Kim, Laura, always a pleasure. Thank you.
Thank you, Sinclair.